So what to do? Monday? Yes.
By the respondent. When I get to know that the petitioner is depositing the name of the respondent. So it is not withdrawn, it is handed over is what is to be directed by this court.
Monday.
Another matter is that we have to mediation and now this come correct.
Wednesday. Yes. Tuesday. The serial number 3 will be called. No, it will be called right now. Where is the question of mentioning it? Yes. No, not why list number 1 and 3. It will reach now. Next page. Huh?
Seeking an adjournment.
Serial number
13.
13.
13. Yeah.
Yes, Mr. Martin on Tuesday. The request of then counsel for the respondent.
Obliged.
Hmm? Serial number 18. This is matter on Thursday.
Serial number 20, please. Serial number 20. The respondent appear for the respondent. The respondent here is not the file RPFC in the file number 188 of 25 along with this matter.
Take that number. You submitted. There is a connected petition. List along with that on 21st. Yes. Call the list. 20. Have you informed the other side? At the request of law and counsel, the petitioner. This is matter after 2 weeks. 22nd. Yes. This court has disposed of the appeal on 8th August 2024 and directed the court to dispose of the suit itself within a period of 6 months. Now a letter is done with the Principal City Civil and Session Judge Bangalore seeking another 6 months time to dispose of the matter. Considering the letter, the time is extended for another 6 months, but the court should make sure that the matter is disposed of and no further extension will be granted. Yes. Letter of extension is this. Third additional family court. What did she say? I took charges, I made calls and so refer to dispose of fire number 2 as early as possible. It is disposed of. Huh? 24th of? This letter was addressed when 4/6. 4/6 it is. Now it is. Why is it placed now? When a letter is dated 4/6/2025, why is it before this court today? Or it appears that 21/6/2025 is a letter. No, 4/6. 4/6 is a letter. Ask the registrar judicial. When a letter is addressed on 4/6, what are they doing till now? Another 1 month for placing the matter. No, but whatever it is, registry shall place it before the court. Letters, now seeking extension is one problem, and placing those letters is another. The letter is addressed by the third additional family court, seeking extension of time for disposing of I number 2. Then counsel appearing for the petitioner submits that already the I number 2 is disposed of on 24 June 2025. The letter is addressed by the learned judge on 4/6/2025. What is today's date? It is placed before this court on 11th of July. Even on the earlier occasion also, this court had observed that the letters are placed even after 1 year, and because there is no as there is no the said letters are not disposed of, and the courts are also taking considerable time. The registrar judicial shall look into this, and why this letter is not put up. A report shall be placed before the court uh, as already in the light of the fact that already the IA is disposed of, no further orders required to be passed. Yes. Hmm. Then I'll adjourn by 2 weeks. Yesterday, when the matter came up, this court has specifically asked the petitioner to file the calculation memo to show that what are the amounts paid, oblique, what are the arrears of the amount. No, Land counsel appearing for the petitioner submits that petitioner has not given any instructions to the council. Lists this matter on 6th of August.
This matter was submitted by your lordship. This is a case of a wife granting the maintenance and the inter-alia, another maintenance under 125 CRPC, and another claim for compensation under the Provision of Domestic Violence Act. Your ladyship admitted the matter, that from the state, and what the director judge filed a counter stating exactly how much is due.
No, 9/4/2025 is the latest order. It says interim order earlier granted is extended till the next date of hearing.
My lord, may I request this? Lordship.
Last hearing, the ladyship directed them to file a counter stating exactly how much is due and what million.
My lords, the execution the petition that's been filed before the trial court is only in respect of the maintenance that was to be given from the date of the filing of the petition till the date of the judgment. I am not denying the fact that they are not paying. They're subsequent to the judgment, they're paying. But the amount that was to be paid from the date of the filing till the date of the judgment is required to be paid. I'll file my counter. My lord may have it on Wednesday.
Interim order earlier granted is extended till the next date of hearing. List this matter on 29th of July. Yes. 29th.
Obliged. Great.
2024. Why you are not, interim order is there? Why you are not paying the process? A week's time, default order. Next. A week's time. Steps are, it is submitted that the needful is done. Does this matter after service of notice? Huh? Huh? Interim order, look at it. Interim order earlier granted is extended till the next day of hearing. Yes, next.
Later it was converted and rectified into MSC. In the MSA, he corrected the address of the affiliate by the complaining officer. But in the judgment of MSA, the same was mentioned and wrongly mentioned.
Now, let's look at the MSA cost title. Look at the cost title here. Who did it? Mega. So look at the appellant, name of the appellant and the address. What is there before the lower court? Hmm. What is the address and all? No. What is there in the MSA cost title that you have to They're not concerned about the special officer. They're concerned about the appellant's name.
Appellant is Tamil.
What is the address?
Tamil Roda, 8061 years.
No GPA in that. But in the order it shows represented by GPA.
Represented by
That is-
Shri Muniraj.
You are not concerned with that. What is the cost title?
Cost taken Tamil Roda. In our
MSA, that's what we are concerned with.
that is a common name. Represented by
There's no GPA there.
This one. In our main order, this is not there.
Then why did you change the cost title from that of the appellate court and this court? How can you? Not in MFA. This order is again a switch order. Where is the order? Not. Let us look at the MSA. What it says. Come to the MSA order. This is the MSA. You're against order passed in the RA. Come to the RA cost title. Tamanna Gowda, so and so, represented by Sri K.E. Manju Raju. No, this is, then there is no GPA here. Uh, uh, uh. While converting it, you have not shown the GPA.
No.
But it has come in the order now. How? No. MFA to MSA. We have made the order in MSA. The cost title shall be corrected as per the cost title that is mentioned in the MSA. Yes. Accordingly, I number 1 of 25 is ordered.
Appear for the respondent mother, my lords.
Yes.
My lords, the NIMHANS report is out.
That has come.
May
Your
I-
Lordship, may I just read that portion, Your Lordship, the NIMHANS report?
In fact, I
Where is
also
the
want to
report?
read certain references. My
First, I
friend
shall
can
go
start.
through the 13.6.
Even I wanted to refer to certain portions of the NIMHANS report. My friend can start and thereafter I'll respond.
13.6.2025. 13.6.2025. Huh.
This is the one. What is this? It's not yet open.
You have one more set, you can pass it on.
I think the another report is also received.
No, this is the 13.6 one, my
No,
lord.
12.6 is this report.
This is
something-
dated 13.6 to the
No,
registrar.
what the office note says is physical copy of the NIMHANS report, or maybe physical copy. They sent it by mail, this one. Hmm. Yes.
Your Lordship, 13.6, this letter is regarding Miss so-and-so, daughter of so-and-so and so-and-so, referred by this Honorable for conducting sessions. Second para, Your Lordship. Based on the evaluations, the child appears to have misinterpreted about abuse, and it is clear that it has not happened. The child has constantly expressed negative views towards the father and unexplained high reluctance to interact with him over the last 1 year, and her responses in the therapy are possible reflections of her not talking to her father for the last few years. The child has been experiencing emotional/psychological symptoms in the background history of a high degree of marital discord between her parents. At the outpatient based assessment has been going on for the past 1 year, and not much progress can be made to improve the father and child interactions, and the inpatient evaluation has not been carried out. The findings should be viewed from the lens of this limitation. Regarding visitation, we have tried to prepare the parents to reach a consensus and prepare the child, but the child appears reluctant to talk to the father. Given these observations, we are planning to refer to the Family Psychiatry Center for facilitation of visitation. For 4 sessions on co-parenting were carried out till now, and further sessions will be continued on outpatient basis. Last para, Your Lordship. Given the challenges faced in the outpatient-based evaluation, and there has been no chance to observe the child in the absence of the mother, with the father, detailed inpatient clinical evaluation is needed for the following reasons. 1, evaluation, detailed evaluation, family history clarification, serial mental status examination, serial ward observations, facilitation and observation of child and parental interaction, management, individual therapy and family therapy. To evaluate the possibility of parental alienation, Your Lordship, this has still not been done. Our objective is to offer neutral evidence-based input in full compliance with the Honorable High Court's directive. This recommendation is made solely in the interest of safeguarding the child's long-term psychological well-being and interests. Your Lordship may kindly recollect, there was an earlier order which your Lordship had referred to, wherein NIMHANS had also specifically stated your Lordship's order was on 10/7/2024, 1 year ago, where NIMHANS has specifically stated that 3 weeks evaluation with the father, 3 weeks evaluation with the mother. Even that so far has not been conducted. Your Lordship, one of your Lordship's similar such order, which your Lordship had passed, went on to the Honorable Supreme Court, and the Honorable
I know
Supreme
that.
Court in that matter. In that matter also, your Lordships, specifically they had stated that it appears to us that mother had obstinately deprived the father of the company of their minor child, overreaching orders issued by the Honorable High Court of Karnataka, and all this, the rest of it is so very similar, your Lordship, and in fact they've appreciated this Honorable Court's the entire objective. Your Lordship, the NIMHANS has very clearly stated that none of the allegations are
In
true.
fact, in that order, I have referred about this case.
No, I'm aware of that order also.
No,
I'm aware.
when I've
Yeah.
passing that order, I have made a reference to this case, saying that particularly in this case, I spoke to the director NIMHANS whether the evaluation of the child is possible on an outpatient
Outpatient basis.
He said it is not possible. Then mother has raised all that what so called, and then we tried to understand whether something could be done. No, from the report of the NIMHANS, it
Now,
shows out nothing can
no,
be
no,
done.
no. May I refer to the NIMHANS report?
Yes.
Yes. My lords may just see.
No, before you're
Huh.
referring to the NIMHANS report.
Yes.
Please tell the court, what is the date of the order of this court?
This
Earlier, just now you're referring.
10/7/2024.
So from 10/7/2024, nearly after 1 year, what is the difference in
No,
the
I
girls?
want to refer to my lords' orders. Kindly see my lords 4/2/25. From the last order of 24, my lords had in fact passed orders that Saturday, Sunday to meet 2 hours, supervised visitation. My lords recollect, are aware of that. Then my lords may just see order dated 4/2/25. Just if I may refer. We were reporting how that visitation was going on, where the mother was taking her with a third party to the father's house. Girl was walking out. Kindly may I just take to para 5 of that 4th February order. Para 5. It is stated that some days session went on well, and thereafter the girl was reluctant to look at the father, and even before visitation is completed, she herself was going out from the house of the father within 40-45 minutes. It is submitted that due to various reasons and at the behest and on being carried away with that is the allegation from the father's side, girl is not interacting with the father, and unless and until orders are passed, it would be very difficult. 6. Learned Senior Counsel appearing for respondent mother submits that mother is making her best efforts to see that girl develops bonding with the father, but so many times she's showing reluctance to even get out of the car. She's hiding under the seat and she's reluctant to go and meet the father, and she stated that she's undergoing counseling with some other with another doctor, so and so. Now, kindly see at para 10, my lords.
Yes.
On the last occasion, it was brought to the notice of the court that father is touching her and she's not comfortable, and then this court made it clear that when the girl is not comfortable, the father should not indulge in any of those activities. The fact remains, this my lords had recorded, the child is, for whatever reason, her behavior is not normal, and both mother and father should accept that she has some psychological issues which has to be addressed. According to doctors at NIMHANS, unless and until she is admitted as inpatient, assessment cannot be done. Mother wants her to have regular therapy, but not as inpatient. This court is conscious of the fact that earlier NIMHANS doctors had said that unless and until she is admitted as inpatient, they cannot assess her. However, considering the fact and circumstances and facilities that are available at NIMHANS right at this point of time, this court is not inclined to pass an order directing the daughter to be admitted to NIMHANS as inpatient. But at the same time, the manner in which counseling sessions are going on, there is not much difference. Till now, report of counselor is not placed, and whatever is placed, they do not contain any details about the treatment. Considering the NIMHANS is a thing, it deems it to pass appropriate orders, and the order to send the child to NIMHANS were passed. The reason my lords, in fact, thought it appropriate to send her to NIMHANS was because she was walking out of the visitation. The 2 hours visitation, in 30-40 minutes, she herself was walking out, and my lords recollect even the videos were shown. Thereafter, now my lords, the cover letter my friend has read out. of the NIMHANS report. NIMHANS has, in fact, may I just refer, every session, if I can please request my lords to see the same report. Every session, they have recorded how the incidents took place, the session took place. I'll just point out some highlights. Page 2, my lords, at the bottom, the pages are there, page 2 of 12, etc. Kindly may I request page 2 of 12. This is the para starts session 2 on 15/2/25. May I read about 10th or 11th line of that para? She reported that, my lords found that line, she reported that she did not like meeting her father. When asked if she always felt like that or this was something new, she reported that it was always so, and she said she had bad memories of the day she was born. She could not elaborate or give reasons about the same, and said that she did not want to talk about this topic. Thereafter, same page, last line.
What is?
No,
what
I
is-
just want to, these are not my words.
No, no,
This
no,
is
no,
what
I'm
the
asking.
counselor has reported.
What is this I'm asking? She reported that she says so and so. She father tried to play with
They
her.
have just recorded what has happened.
Reported that she
Huh.
did not like meeting the father.
Yes.
When asked if she always felt like that or this was something new, she reported that it was always
Always so.
She had bad memories of the day she was born.
My lord, she's an 8-year-old child. Now, whatever these are counselor's report, not mine or his report. This is NIMHANS.
Saying that sentence itself.
It may not make sense. It may not make sense because nobody can remember.
That all the more shows that something is really not.
I just
right.
want to point out.
Yes.
I just want to point out few things which I found relevant to point out. Then the same page, last line, later during another, next page, my lords, later during another activity.
At page number 3.
Yes, continues on page number 3. The child was asked if her father could be involved in the session. She refused, saying she did not want to talk about this. And when asked the reason, she reported that it would be talking about the same topic. When asked if she had told the reason to anyone else, the child said she had told her mother but couldn't remember what was told. The session ended with a play activity. Then session 4 starts. In the session 4 paragraph, about the 7th, 8th line from the bottom, when asked about the last visitation with the father, she reported going there for an hour, seeing a film for 50 minutes that she had already seen, and then coming back. When the child persisted with saying that she did not want to talk about it, the therapist asked her the reason at the time of which she was scared to talk about it. So again, these reasons were asked. Then my lords may go to page 7. Page 7. 7 of 12. The first para about the 15th line, upon further exploration. My lords found that portion. The sentence starts in the middle of the para, upon further exploration. She shared feelings of being worried and uncomfortable around her father, though she was unsure of the reasons. The therapist validated her experience and appreciated her willingness to open up, gently encouraging her to think further on these feelings and consider discussing them in future sessions. He also invited her to use strategies such as journaling or speaking with a safe adult or peer whenever she felt distressed. The therapist.
Are you reading the first paragraph of that or the second paragraph?
I'm sorry, I'm reading first para, my lords, in page 7 of 12.
7 of 12.
Yes, sorry. Page 7 of 12. The first para, middle of the para, upon further exploration. There is a sentence which starts somewhere in the middle of the para. Upon further exploration, upon further exploration, she shared feelings of worried, in quotes, and uncomfortable around her father, though she was unsure of the reasons. The therapist validated her experience and appreciated her willingness to open up, gently encouraging her to think further on these feelings and consider discussing them in future sessions. He also invited her to use strategies such as journaling or speaking with a safe adult or peer whenever she felt distressed. Then the same page, second last line, same page. She shared that she felt, my lords found that, uneasy and bad due to events that had taken place in the clubhouse during the 2 visitations to her father, which led to her discomfort around her father. Upon further gentle exploration, the child described that she did not like being forced to play with her father. When asked to elaborate on the nature of play that had caused her discomfort, she expressed that she simply did not enjoy playing with him. The therapist explored whether this feeling was experienced with other individuals, and the child clarified that it was limited to her father. Then, my lords, just kindly leave the next 4-5 lines. Then she changed the version. My lords found that line. Same para, about 10 lines from the top. Then she changed the version.
Page number?
My lords, this is page 8. Page 8. I'll just read from the top. To her father, which led to her discomfort. Upon further gentle exploration, the child described that she did not like being forced to play. My lords have found those lines, right? Forced to play with her father. When asked to elaborate on the nature of play that caused her discomfort, she expressed that she simply did not enjoy playing with him. The therapist explored whether this feeling was experienced with other individuals, and the child clarified that it was limited to her father. Now, my lords, kindly 3-4 lines, my lords may skip. In fact, that day I was born, that is what the therapist explores. Then she changed the version. My lords found that line. Then she changed the version to, I don't like my father for a long time that I remember. The exploration continued regarding the nature of the discomfort, and the child described an incident at the clubhouse where her father picked her up and held her upside down, and she demonstrated it in the session using a doll. She also expressed how her father had touched her on her bottom. Her feelings were acknowledged. At this, the child inquired whether she would have to meet her father that day. When asked what she wanted, she expressed that she did not wish to meet him, explaining that his presence made her feel uncomfortable. At this point, the therapist explained the presence of a court-ordered visitation arrangement and emphasized that court orders are binding and apply to everyone. The child mentioned that she had been told it was her choice whether to meet her father. The therapist affirmed that while the court's order is there, the child's preferences are also important and would be communicated. He acknowledged the challenges of speaking about sensitive topics and encouraged her to take a break. Then, my lords, kindly skip 2-3 lines. The child again verbalized that line. The child again verbalized about not meeting her father, and the therapist again affirmed that her choice would be respected and communicated. Then the child asked about what would happen after the session. The therapist explained that he would be meeting with her parents to provide feedback. The child remained silent, and the therapist gently reiterated that confidentiality would be maintained and that the ultimate aim of the sessions was to support her. He then explored whether she had ever shared her feelings of discomfort with her father, to which the child responded that she had spoken to her mother about them and maybe to the court, but not directly to her father. When asked whether she had expressed her discomfort during play with her father, she responded negatively. The therapist then inquired about the frequency of the events the child described, and she responded that the incident involved being turned upside down occurred only once, and the bad touch may have happened twice. The therapist gently offered that at times parents may engage in physical or playful interactions with their children as a means of expressing affection, which may not always carry a bad intent. The child acknowledged this possibility but clarified that the experience had made her feel uncomfortable. The therapist acknowledged her feelings and explored what made her think that her father's touch had been bad intent. The child replied, I don't know. When asked whether it was more of a feeling or her belief, she affirmed that it was a feeling. It was also inquired whether an incident like this had happened at other times, to which the child responded that it had happened only during the 2 clubhouse visitations. The conversation further explored the context of the incident, including whether her mother had been present during the visitation. The child expressed that her mother was sitting at a distance within the clubhouse during the visitation. It was also clarified, continues on next page, my lords, that the visitations happened in an open space where many other club members were present in the area, in the same area. The therapist also gently inquired whether the child had experienced similar discomfort with other individuals, including strangers, to which she responded negatively. At this time, the child expressed a desire to end the session. The session was concluded with a brief breathing exercise and the use of a teddy bear as a self-soothing strategy. The therapist provided a rationale for the exercise, explaining that sharing personal experience may be emotionally difficult, and encouraged the child to hug the teddy bear. Now, my lords, may see page 10. Page 10. About 4th or 5th line from the top. To explore the origins, that line. To explore the origins of her discomfort, the therapist inquired about when her strong feelings towards her father had begun and whether they were linked specifically to the clubhouse visitation. When the child responded with silence, confidentiality was reiterated. The child then shared that she felt uncomfortable when her father would force her to engage in certain behaviors like eating food that she did not want or being asked to give gifts to others. She explained that this caused her distress. The therapist validated her distress and encouraged her to guess possible reasons behind her father's actions. The child expressed that maybe her father wanted her to eat, which the therapist acknowledged and appreciated as a thoughtful insight. When asked whether anyone had advised her to feel this way toward her father, she stated that no one had and admitted that these were her feelings. The conversation then shifted to her sleep routine. Then, my lords, may just see page 12, the last. Page 12. These were all the sessions. The last page 12, the title is Sessions on Preparation for Visitation. The counselors, the doctors had sessions with the child about visitation. And this is their record. The third para, session 2. Session 2 on 26/5, the child was seen separately for a session and discussed her interests, routines, well-being. She discussed her interests in summer vacations and spontaneously said she could not take a long vacation since she has come to NIMHANS for sessions and she wished that she could stop coming to NIMHANS. On gently probing about the reasons, she reported that she could do other useful things in that time, and on asking whether she finds NIMHANS visits to be useful, she said she doesn't know, but she doesn't like coming to NIMHANS and that the sessions are okay for her, but she does not like visitations. And then that same para, about fourth or fifth line from the bottom, on discussing preparedness regarding visitation and support needed from NIMHANS team, she reported that she does not want to have visitations with father and NIMHANS team could help by communicating the same to court. She refused to discuss further about the visitation. Then session 3, the third line, child reported that she is not willing for preparation towards visitation and no support will be helpful for her and she refused to discuss further. Parents were seen together. Discussion with parents focused on reaching a consensus regarding visitation. Mother was of the opinion that child is afraid and not willing of visitation and should not be forced and that NIMHANS can act as a third party for visitations and raised concerns regarding safety of the child during visitations.
What is this girl's safety raised by mother? What does it mean?
No, the supervised visitation. Because the girl reported that on 2 days in the clubhouse, which was also reported to my lords,
In spite of the fact that the mother also understands, girl is telling something which has not at all happened, but still keep on saying about her security concerns. Is it not that she's validating what the daughter is saying?
No, may I just respond? What I read out were the session notes made by the NIMHANS.
No, that's what they have recorded.
They have recorded the session notes. These are all recorded by them.
No, the mother has.
Yes, she has said it, and I'll give my lords the reasons why the mother has said it. The only reason the mother has said it is because, as reported in the earlier session, the child herself has said that on 2 visitations in the clubhouse, she felt uncomfortable with what happened.
She's feeling uncomfortable for everything without any basis. That cannot be the basis.
My lords, I don't want to read in and make any further judgments. The 2 things she said is that one is the father put her upside down, and then on one occasion he touched her bottom, which she said made her feel uncomfortable. Now, whether that was done with a good intent or a bad intent, it is for no one to assume. Nobody can know because the father and the child were there together. But the child has reported that it made me feel uncomfortable. So the visitation sessions were held separately with the child. In fact, the cover letter, what I want to state, my lords, is that ultimately, my lords, even the supervised visitation that my lords directed, we were carrying out.
She said that.
We were carrying out.
No. There also she said that father was touching her before everybody.
In fact, the video, my lords, the video that I showed my lords, and based on which my lords made that record, he's forcing her, touching her, my lords. In fact,
before going into all that,
yes,
why the mother is wasting her time, course time, child's time by doing all this? Why not 3 weeks of admission won't work out?
My lords, the child is going to school, she has
What
exams.
school? Overall development of the child is what is
No, I
important.
can ask the mothers here.
So we
Mother
will
is-
pass an order.
No,
No,
I'll ask-
no, I'll not, will not waste
In
further
fact,
time
I
on
just
this.
want to make one, may I just make one submission?
yes.
My lords, may just
I've
see
already
the
given
cover.
I've given
No.
a long hearing.
Yes,
a
yes,
long,
we are fully.
No, this is not required now. I
My
think
lords,
we can't waste our time.
My
like
lords,
this.
may I just look at, just for a moment, the cover letter, just for a
Yes,
moment.
we will
Just
do.
the
We'll
cover
look
letter.
into.
In the cover letter of 13.6, what they state, in fact, that regarding visitation, we have tried to prepare the parents for a consensus, but child appears reluctant. And then, in fact, they state that as at one point they have stated that we were unable to see the interact with the child without the mother or father. In fact, every session has been held by NIMHANS as per their requirements. Child has gone. Whether parents are asked to come or not, they are waiting outside. Only if they are asked to come, they go in. So whatever the NIMHANS wanted, if they want the child to interact with the father is there, they can easily call him. Mother has not stopped that. Mother has not stopped that.
That's
So
precisely what it is.
whatever
That
they
is what,
want to explore.
What the doctors are repeatedly saying, even the director NIMHANS also said.
Yes.
With these kind of disputes between the parents, no, they do a counseling for an hour. She go home. She's there for the next 23 hours with the mother.
Yes.
That's not possible. That's not possible. That's what precisely he said. For her, for in this case only, I called him because she's looking at her age. And
But I'm just wondering aloud as a parent as well. I'm just wondering aloud.
let them.
What happens to the child's school if she is put inpatient? May I just take instructions?
Your Lordship, at the age of 8, I don't think she's going to miss her doctorate.
Yes, because
In
the
fact-
mother is more concerned about her marks than her.
No, at 8th standard, there is
than
no
her.
mark. No, in fact, the mother just mentioned to me that based on my lord's earlier orders, for 1 week inpatient, she was.
What all she did that time, I also know.
1 week.
She made her to travel 24 kilometers during the summer and all resulted in it.
She was
There is
staying
so.
there.
All
Remember-
of this is covered
remember
in
all
the
those
Supreme Court
orders.
judgment,
No,
Your
no,
Lordship.
this is
Even
not,
about studies,
this is
Supreme
not
Court
going to
judgment
work
has
out.
covered it.
And
I'm sorry. Now,
the daughter's psychological condition is it is at a very alarming stage. It doesn't, with all these therapy sessions, nothing is going to happen. We have to leave it to the doctors. Court exercising the parent patriarch jurisdiction
only
will
we
take
are
into.
ultimately. May I just make one submission?
Yes, yes.
Ultimately, we are in my lord's hands.
Yes.
My only concern is she's an 8-year-old child.
Yes.
To put her into an inpatient situation, and I would say even for any parent, father or mother, ultimately that should be the concern. We are only concerned about a 8-year-old girl
That is
being put
exactly,
inpatient.
Mr. C.
I feel, my lords, with great respect, that is a very, very severe suggestion that even
I think
NIMHANS
that is already, if you look at the other judgment, the Supreme Court has also considered this,
Yes.
what it is.
Correct.
In fact, I'm just curious. I may not be fully aware of the other judgment, although I'm aware of the case. Whether in the other judgment also fully inpatient, my lords have ordered.
That's what ordered.
And whether
What has happened, but only difference in that is, now
1
by
minute.
the other day, yesterday when the matter came up,
yes,
when the NBWs were issued and the available warrants were issued against the mother, they have come and they have filed a joint memo, all they've compromising everything, divorce, visitation, everything is settled. And that's how it ended up yesterday.
in fact, the Supreme Court order, if I can just read out.
Your
and
Lordship,
if-
Please read.
none of
If I
this
can
would be
just read
necessary.
out-
I understand
No.
her concern that an 8-year-old child goes alone
May I
in the
just
what is the
system.
concern of
But
the
they
court?
have
The
brought
conflict
into
is
this
only that.
situation. Had the mother not done all of this, the child would not be in this situation.
Pause.
So therefore, it is her own doing that the child would have to
May
go
I-
in
may I
there for
just
so
read
long.
Para 16.
And
Just for my
all of
understanding.
what learned senior
No, let her-
counsel has
let her
stated
read-
is
let her
covered in
read
the
that,
judgment.
paragraph.
I'll just read out because ultimately, let us, we are only doing all this effort in the child's interest, nothing else.
That's what everybody is
We are
interested
only
in.
interested in that. Para 16, if I can just read
Please
out,
read.
my lord. We have already directed that the child would be taken by the district child protection officer along with the mother to NIMHANS on so-and-so date at 11:30. we clarify
Independent.
that after the admission of the child for her independent evaluation, the doctors in attendance would take a decision regarding stay of the mother with the child or her visitation during the period.
Supreme Court has gone
No, of course,
a step further.
we are bound by what the Supreme Court is, or her visitation during the course.
No,
of
no,
the-
we are not. There's a twist here. She's now trying to say, in this we are bound by the Supreme Court. Therefore, trying to restrict your lordship to not pass any other order to it.
I'm not.
We can't read everything in.
No, let
I
her,
am
let her
not
complete and
putting
understand
any,
what is,
I'm
what
only
is that
trying
she
to
wants to
understand
say.
how the Supreme
Yes,
Court has
please,
evaluated,
please
has
read,
directed.
please read.
The doctors in attendance would take a decision regarding stay of the mother with the child and or her visitation during the course of evaluation of the child at NIMHANS. Likewise, the doctors in attendance would also take a decision regarding visitation of the father on such date, time and frequency during the period of evaluation of the child at NIMHANS. Such a decision would also be taken regarding the visit of the District Child Protection Officer on completion of the evaluation exercise. NIMHANS shall furnish a report to the Registrar Judicial of the High Court of Karnataka in a sealed cover. Post-evaluation, NIMHANS shall permit continuation of the custody of the child with the mother as previously ordered, with visitation facility for the father depending on their evaluation. Now, I'm only trying to clarify whether any timeline for this, if my lords are suggesting inpatient.
3 weeks.
Sorry,
3 weeks.
whether 3 weeks was, I mean, if my lords
Yes,
are saying I have no
the
reason to
doctors,
doubt.
whatever the doctor suggested, that has to go on. Now, at least on the last occasion, this court has passed an order that mother could be with the daughter. But the Honorable Apex Court said whether the mother's presence is required or the father's presence, that the doctors will take a call.
Doctors will take the call, but ultimately they said the doctors should do the evaluation as per their
Now,
recommendation.
here, there is no treatment going on. They're only
Correct.
trying to
an
evaluate what is the
evaluation.
difficulty of the child.
It is an
No,
evaluation.
that is in the long run is going to affect the child. If the child grows up with this feeling that father has done something to her, does the mother think that it is all right? And with 1 year,
Definitely.
in a matter of 1 year, she couldn't achieve anything. That's what court has given her the enough chance to, whatever possibilities she can.
My lords are right, but ultimately the only submission, my lords, is that the concern, I just want to, just for a brief moment, the difference in this case and the other case is that in the other case, which led to
Other
this,
case is much, much better than this. Because
I would, with great respect,
no,
disagree to an
because,
extent.
no.
I would
In the
disagree with
other
great
case,
respect.
the child is not attributing all these kind of bad touch, good touch to the father.
Yes,
She
there
just
was-
says, I don't
I
want
don't
to see
want
him.
to be, but in
And
the
this
other-
case, she says something
No,
which
but
is,
in
nobody can believe it.
In the other case, the reason why I state it's different is because there were orders for visitation passed by the court and they were repeatedly flouted by the mother. And therefore, the ultimately contempt and all
We
these
are
other-
on- we are on
we
the-
have not ever, the mother at any
No, not
point of
on that.
time
You can't
have-
compare it that way. You
No,
have to
only to
compare
that
it on
extent.
the psychology of the girl and what is the mental
My
state.
only comparison is that whenever visitation orders have been passed, the mother has never tried to flout it or disobey.
No, let's not put the
Yes.
girl into this kind of tension forever.
My
Let
only
her, first of all,
concern
let her
is
get out of all this
if the
psychological
inpatient-
issues.
The only concern, my lords, is inpatient for a young girl of 8 years. She's a school-going kid. And to be in a hospital environment,
Not able to
I think even
understand.
we should be concerned about that. That's putting her in a hospital
Do you think
environment.
do you think that the doctors are not aware of it, or doctors are not concerned about? If they are not concerned about her health, why are they like they want patients to be admitted
my
in
lords,
the hospital?
My lords may just see, just the reason my discomfort is there. I read out what, according to me, were the relevant portions of each session findings.
Yes.
After the session findings, in the session findings, the girl, whether it is true or false, it is only for the girl and father to know what happened. Girl has said 2 incidents happened in the clubhouse, which made her feel uncomfortable. Now, the NIMHANS covering letter, the covering letter says, based on the evaluation, child appears to have misinterpreted about abuse and it is clear that it has not happened. Child has expressed negative views. Now, I'm only asking, the evaluation, the session notings are there where the child says XYZ incident happened. Now, the finding given by the team to say it is now clear that it has never happened.
No, no.
My lords, how can
No,
any.
let's not go into that. Let's not attribute anything to the doctors, anything
No,
to
no,
them.
it is not attributed.
Ultimately, if they are not there, the girl will be nowhere.
No, no,
So let's
no,
not
it is not
attribute
being
anything to them.
attributed.
Your
but
Lordship,
the
one
reason
sentence
the
which
reason I'm
learned
saying-
senior counsel read
reason
itself
I'm-
states it.
No,
Your Lordship,
no,
two sessions.
No, what is the reason for this court to take that step of taking the dog, admitting her in NIMHANS, that order is a detailed order.
Yes, yes.
Wherein before this court, without, even the mother has accepted
In fact, my lords
Stating-
interacted with the child.
with the child.
My lordship.
And what she was saying, the videograph of the entire session was there, was sitting between, even the advocates were there. She is also there.
No,
And
no,
she
I've
also
seen the
accepted
video.
that.
I've seen the
Nothing, there
video.
was, she is under some kind of we don't know what is that, because we are not competent to say what is her state of mind.
In
So
fact, I've
let's give
seen
it
the video. I have also seen the video because I said, let me see to know exactly what has happened. And the mother was not there, and there were other one or two videos where the father is holding the child from the back. At least that is the video I saw. That the child is on the lap or
No,
something.
no, which one you saw?
I
Like
have
all of them sat down and she was doing some activity,
Not
sitting on
that,
the floor.
no.
That's the
No,
one.
no,
That
no,
is the
that-
one when
no,
the
not
court
that
has
video.
interacted with them.
Not that
Yes.
video. There is another video.
No, that's the video when the girl came and expressed to the court that father was doing something which is not right. Then all of them were there in their presence. She said. Then the court could understand that something is not right. That's why all this. No, we have wasted already 1
Now, my
year's time.
only submission is, if could my lords reconsider inpatient? Because
Not
that is,
inpatient, nothing is going to happen. We will not. Now the doctors will say they will not do anything. We can't ask the doctors to do the treatment as per how we want
can
and
I
how the
just
mother
take, can I
wants.
just take?
Please
one?
ask her.
Your Lordship, the portions that have been read are only the portions that it was convenient. There are so many other portions, Your Lordship, which are very positive.
I was
The
seeing that.
other thing also is, if they have any difficulty with NIMHANS directly of giving a clean chit, then it also records, they ask the child and the child has responded, did this happen any other time? No, it happened only during the clubhouse, which means all through her life it's never happened, and it seems to have happened only at that particular
I
time.
only want to make
Whatever-
one.
That is the words of the child itself.
Whatever the girl says, let's not take into consideration, because as of now, we know that her state of mind is
Yes.
not correct.
Yes.
That has to be evaluated by the
Absolutely.
doctors and they should give the report. Till such time, let us not go into any of these
Please,
issues.
please.
That's number one.
Yes.
Number two, as observed by the Honorable Apex Court in the other judgment, this court is not going to pass any orders with regard to the visitation. Whether the mother's presence is required, father's presence is required, how it has to go forward, that they will decide.
Please, please.
Then may I just make my sub, ultimately my lords may pass orders, but my instructions are that inpatient, which was done last time by the orders of my lords for a week, was extremely difficult for the child. As per the mother, she fell sick. She was
That I'll
physically
record.
sick.
I will record
Yes.
all the
And
reasons why
therefore-
she has felt sick.
And she has fell sick, and that inpatient was not at all in her interest as per the mother's view. Thereafter, my lords agreed for outpatient. Outpatient
It is
is what
going on for 1 year.
where-
without
it
any
has been-
change.
Now, clearly, during the outpatient in evaluations and interactions, the girl has said that she is not feeling comfortable. And therefore, my lords, for inpatient, certainly we are not agreeable, but let this be recorded, my lords, that
Yes.
the inpatient is not something
Yes.
that the mother is agreeable,
Yes,
as it will affect the child. She has exams now. She has 1 month of exams in school, which she has to finish her academic year. And in fact, even this has gone on for a year. In fact, all this is weighing on the child.
No, mother is not bothered what's happening with her.
No, mother is
But
certainly
mother is
bothered
only
about the
bothered
child.
about- Mother is only bothered about, if anybody who is
certainly
very
the
good-
mother is
No,
bothered
no,
about the
who
child.
is very good at studies, that's the only thing that's required.
Not studies, my lords. It is
Then
not whether she
If
gets
she-
a A
that
grade or B
shows
grade.
There are no bona fides on the part of the mother to see
In
that
fact,
the
mother
the
has-
overall development of the child
In
is
fact,
taken care of.
the court has recorded that even when NIMHANS was going on, the mother was taking her to Manipal. If
Why
the
should
mother
she?
is-
No,
Because
what
at
is
that
it?
time,
No, she doesn't have any trust on an institution which is
in
considered
fact,
to
even
be a.
before NIMHANS, I'm only making a submission that the
And
law
what is
court
the
has
outcome of
recorded.
it? What is the outcome of it? That's what we are
Because
bothered
outcome
about.
takes time. Outcome does not happen with great respect.
1 year,
Outcome in
1
the-
year also, but what is the difference? Act as it is, as it was before
this
the court.
is, this is
even
6
till now
weeks.
it's
It is not 1 year. It is 6 weeks. No, it is, my lord.
The last order is on 10/7/2024.
No,
And
at
even
that time-
before
at
that,
time
it had
there was no
started.
counseling. With respect, I just want to clarify. These sessions, in fact, the 10/7 order.
When is the order
that-
passed by the court?
My lord, this order
On
is,
12/3/2025.
on 4/2, on 4/2 from February.
She's asking.
The
On
counseling for NIMHANS was
12/3/2025,
On only
an order
from,
is passed by
4/2.
this court.
It is not from 1 year, with great respect.
As per the order dated 4/2/2025 passed by this court, a report is placed before this court by the director NIMHANS, and basing on that, this court has passed an order on 12/3/2025. Extract the entire order. Basing on the said order passed by the court, a report is placed before this court. The report dated dated 13/6/2025. This covering letter, entire letter, extract and paste it. Today when the matter came up, both the senior counsel appearing on behalf of the mother and the father have advanced their arguments. Then senior counsel appearing on behalf of the father submits that the report of the NIMHANS is very clear that unless and until she is admitted as inpatient, it would be difficult for the doctors to evaluate the girl. She had relied on a judgment of the apex court in case of Ms. Amrita Sinha versus Sweta Sahai, arising out of special leave petition C number 17006 of 2025, dated June 25th, 2025, wherein in a similar facts and circumstances, the Honorable Apex Court has affirmed the order passed by this court, and para 16 of the order, the court had observed as follows. Extract para number 16, 17, and 18. Basing on this judgment, it is submitted that this is a fit case where the girl has to be admitted as inpatient. Then the senior counsel also points out that this court had passed several orders in this matter, starting from starting from 5/6/2024. This court had submitted that right from 5/6/2024, several orders were passed by this court. And in fact, earlier, by order dated 10/7/2024, had directed the girl to be admitted in the hospital. Thereafter, mother has come before this court and expressed that the girl is not comfortable. And thereafter, on several occasions, this court has also granted visitation. And it is stated that the mother is taking the girl to NIMHANS. Senior counsel submits that there is no change in the attitude of the girl towards the father, and that has been recorded by the NIMHANS in the report that is placed before the court. It is submitted that unless and until the girl is admitted in the hospital, it would be difficult for it is difficult for evaluation. And senior counsel appearing for the mother submits that the mother, it is not acceptable for the mother, for the that for the girl can be treated as outpatient, inpatient. The facilities at NIMHANS are not good. And earlier also, when the girl was admitted, she had to face a lot of difficulties. And considering her,
Fell sick also, my lords, may record. She fell
sick. And because considering all that, thereafter, court had directed the NIMHANS to evaluate the child. It is submitted that the girl is going to school. If she has to be admitted, she's having exams, and and it would have an impact on her academics. Even on that count also, admitting the girl in NIMHANS is not appropriate in the interest of the child. Further, according to the senior counsel, the counseling sessions, like how this is going on from the last 6 weeks, should go on. And basing on that, basing on the further report from the NIMHANS, the court can pass orders. The senior counsel has pointed out certain paragraphs from the report of the NIMHANS. In this, I have pointed out, I have underlined all that you extract. Entire report, wherever I have underlined that I extract. It is submitted that the girl is showing utmost reluctance to meet the father. And in these circumstances, the further sessions with the NIMHANS will be in the interest of the child, but not admitting the child as an inpatient, considering her age and her well-being. Anything else?
Also to say that whenever the orders for visitations were passed by the court, we have
It
complied.
is submitted that the
We have
mother
never
is
tried
not
to-
with the order,
They have not been
with the
complied.
order of visitation. And in this case, the
Supervised visitation that my lord, the supervised visitation with third party
and,
supervision that my lords had.
And in this case, as the senior counsel was relying on the judgment of the apex court, in the said case, there was constant violation from the mother in complying with the order of visitation, and the same thing is not there in this case, and the mother is always ready and willing to honor the orders passed by this court. Hence, the court may not pass orders admitting the child in an NIMHANS. Hurdle and the senior counsel on either side, there is some material non record. In this case, when the matter initially came up before this court, where the father is seeking the visitation.
Apologies, my lords, apologies. May I just make one more submission? In the cover letter, what NIMHANS says, given the challenges faced in the outpatient-based evaluation, and there has been no chance to observe the child in the absence of the mother with her father.
Mother, comma with her father. The comma is critical.
Mother, comma with her father.
Read it. Your
No,
lordship,
no.
I have been very patient all along. Everything that they said is
I am-
recorded. I have not even insisted
I'm
on
only
what are the
reading what is
positive things.
there.
Here, I will not let them misinterpret. It
I'm
says
not
there has been no
misinterpreting.
chance to observe the child in the absence of the mother,
With her
comma,
father. Yes,
with the
yes.
father. Meaning with
Yes.
the father we could not observe. With the
Yes,
mother they have
that is
observed.
the same thing
No,
what
no,
I'm
no.
saying. I'm only saying the NIMHANS had the full freedom to have the sessions in any combination that they wanted. Whether they want the child alone, whether they want the child with
They are
the
not
father.
referring to that
Nobody
1
has
hour.
a-
They are not referring to that 1 hour. For the child, even in that
Even
time
for-
also, she says that after a time,
No, at
I
any
do not
time-
want,
at
I
any
leave from the
time,
place.
if they wanted, in fact, to observe the child and the father, We were at their instructions.
No,
They can call anybody however they want to
the
observe.
father has fought for the visitation.
Yes.
When it is brought to the notice of the court that the mother is
We have never,
along with the child in Calcutta. And it is submitted that as per the orders passed by the court, the visitation rights will continue till vacation after the child comes back to Bangalore. This order was passed on 23/4/2024. Then on that day, it was brought to the notice that whenever there is visitation with the father, the girl is undergoing tremendous mental stress. Then on 5/6/2024, this court has passed the following order. Extract that order. Then on 12/6/2024, this court has, after the visitation went on and after interacting with the child, this court has passed order on 12/6/2024. Extract that order also. Then on 9/7/2024, the doctors at NIMHANS have placed a report before this court, wherein they have found that the child required 6 weeks of admission in the hospital as an inpatient. Then the matter was adjourned to 10/7/2024. Then on 10/7/2024, a detailed order was passed wherein the girl was directed to be admitted in the hospital. Order dated 10/7/2024 also you extract. Then on 18/7/2024, that the mother has moved a memo stating that her exams are starting from 22/7/2024 to 26/7/2024. As such, the girl can be admitted after Friday, that is on 26/7/2024. But however, and this court has directed that the girl shall be admitted in NIMHANS on 22/7/2024. Then on 24/7/2024, it is submitted that as there was no special rule, the girl was not admitted. When the matter came up on 1/8/2024, it is stated that now the mother has come up with an application for modification of the order, stating that the washroom, the room in the hospital are not clean and not well maintained. As such, the girl has developed urinary tract infection and she is admitted in the hospital. And hence a petition is filed seeking modification of the order dated 10/7/2024 and permitting her to stay at her residence and visit NIMHANS for psychological evaluation as and when required. Then this court has observed that when they say that the hospital conditions are not hygienic, they should have brought this to the notice of the hospital authorities. And it is a responsibility of the hospital authority to see that the child stays in a hygienic condition in the hospital. The affidavit that is filed before the court do not disclose that such an effort is made. Every day, the mother was taking the girl to the school. The distance between the school and the hospital is about 25 kilometers. And from the last 3 days, the girl is made to travel that distance. The court has also observed that the mother is not much concerned whether that contributed to the dehydration and the stress of the girl. But according to her, only the hospital conditions have contributed to this.
Your Lordship, also that she unilaterally pulled her out of the hospital and went and took her to Manipal and put her in.
This
So we don't know
schooling-
whether there was any such incident at all also.
No, in
She just
fact,
pulled
the
her out and
school
she
thinks
decided to go
the
and get some medical
doctors
records.
This court has
themselves
also
said
observed
to
that
take
this
the
is the
child
high
to
time.
school.
The parents have to realize this. It's a responsibility of the hospital authorities to see that the patients stay in a hygienic condition. And if the conditions of the hospital are not hygienic, as complained by the mother, it is the responsibility of the hospital authorities and they should take care of them. And this court has passed an order that till the next 6 weeks, whatever the doctors say, the parents shall follow and they should not come to the court until the 6 weeks period is completed, until the report is given by the NIMHANS, and both the parties were directed to cooperate with the hospital authorities. Then on 30/8/2024, an order is passed for this court, and this court had recorded the report placed before this court by the NIMHANS, stating that for various reasons they could not give the treatment to the child, and they have also stated that for the purpose of school, the girl is leaving at 6:30 a.m. and coming back in the evening. Earlier, the school authorities have also given permission for a period of 6 weeks for the child. Though the court had passed an order long back by filing one application or the other, and on one pretext or the other, by the mother, so far treatment could not be given, and they could not analyze the state of mind of the girl. Then finally, the court had passed an order directing the mother to admit the child on 31/8/2024 at NIMHANS, and the mother shall adhere to the advice given by the doctors. And she cannot take her independent decision and cannot take the child wherever and whenever she wants. The doctor shall treat the child, and the interest of the child should be the paramount consideration and not the request of the mother. Then again, this court has passed a direction to the NIMHANS to evaluate the child. Then again on 25/9/2024, this court has observed that in spite of an order passed for this court, in spite of several orders passed for this court, on one reason or the other, the mother has not joined the child in NIMHANS. Then when the court has also observed that as a mother is not complying with the orders of the court, this is a clear case where a suo motu contempt proceedings have to be initiated, and directed the matter to be listed on 1/10/2024, and on that day appropriate orders will be passed by the court. On 1/10/2024, when the matter came up, it is submitted by the mother that there is a lot of reluctance from the daughter, and in fact she has been taking her for counseling. Now she has improved emotionally and otherwise. There is a lot of change in her. Concerning the said submission, though the mother has blatantly violated the orders of the court, considering the welfare of the child, the court made an interim arrangement from 6/10/2024 to 30/10/2024, where this court has permitted the father to exercise a visitation for 2 hours between 6 p.m. and 8 p.m. at Prestige Shantiniketan Apartments cafeteria, and the mother was directed to cooperate with the visitation. In this order, dated 4/11/2024, this court has recorded what has transferred on the earlier occasions, and about that the girl is not feeling well, that she's suffering with urinary tract infection. As such, she could not join the girl in the hospital. This court has observed that when that is the case, mother has not even bothered to come up with an application before the court. And once the father moves the application for visitation, now it is stated before the court that the daughter is not interested. Daughter is showing resistance. And there, the mother tells the court about the therapy sessions. Then again, another order was passed. Then at paragraph 7 of the said order, this court has observed that what has been looking at what has transpired in this case right from April 2024. The court feels that there is a lot of reluctance from the mother to admit the daughter in the hospital. It is stated that the girl is not interested. This court observed that the mental condition of the girl appears that she requires calm treatment. The mother cannot submit before the court that the girl is reluctant, and the court exercising the parent patriarch jurisdiction has to take care of the welfare of the children than the concerns of the parents. Then the court also observed that the court has personally interacted with the doctor to find out whether the inpatient treatment is required or not. Then, considering the concerns of the mother, this court passed an order directing the passed an order that by the next date of hearing, the father shall come up with the details of hospital and the facilities that are available at any other hospital for the inpatient treatment of the daughter, and also granted the visitation. Then it is submitted that the visitation went all well compared to the last occasion. The girl interacted with the father and the grandmother, and there appears to be some improvement in the girl. And if the same arrangement is continued for some more time, it is submitted that it would be in the interest of both the father and the daughter. But the mother submits that though she interacted with the father and the grandmother, but before and after the visitation, the girl had developed some health issues. According to the mother, she is under a lot of stress. Then the court has observed how, when the order is passed by the court to join her in NIMHANS, for that the mother's response is that the girl is not comfortable. She is showing reluctance. When an order of visitation is passed, it is stated that she is going under a lot of stress. Then this court has observed that when something is not in the interest of the girl, whether she likes it or not, whether the girl likes it or not, it has to be done. And the court has a responsibility to take care of the welfare of the child. And the court had continues the visitation on 17/11/24 and 24/11/2024. Again, on 27/11/2024 also, this court has passed the order granting the visitation. Again, the matter came up on 13/12/2024 as it was paucity of time, and as agreed by the parties, the court had passed a order of visitation. Then when it came up on 17/12/2024, again an arrangement is made for visitation. Then on 9/1/2025, there is allegations that father is forcibly feeding her, touching her, which is making her uncomfortable. The maid and the neighbors are present. The girl is not comfortable. And both the parties, the mother and father, mother makes her own allegations, father has his own defense for that. Considering all that, the court had again granted visitation and directed the matter to be listed on 3/2/2025. Then on that day, the court had directed considering these allegations that the father is touching her inappropriately, then the court felt that this cannot continue like this, and there has to be a evaluation on why the girl is saying these kind of things referring to the father. Then an order is passed on 4/2/2025 that on every Saturday from 8/2/2025 to 8/3/2025, the girl shall be taken to NIMHANS Bangalore for counseling. And during the counseling, as per the requirement of the doctor, if they want to analyze in the presence of the mother, or they require the mother uh, of the father, or they require the mother's presence, accordingly the counseling shall go on. And it is also directed that the doctors at NIMHANS shall fix a convenient time on Saturdays, and counseling shall go on basing on their assessment. A report shall be placed before the court by 10/3/2025. That basing on the said order, then on 12/3/2025, a letter was placed before this court where the NIMHANS have stated that they require another 6 to 8 sessions. And as per the recommendation, this court has directed the child shall undergo 6 to 8 sessions. Then that order, the court observed that when the girl is undergoing the sessions, the NIMHANS doctor shall also assess the influence of both the father and the mother on the child, and both of them shall also be counseled simultaneously, and a report shall be placed before this court. Basing on that report, the basing on the said order, the present report dated 13/6/2025 is placed before this court. In this case, the daughter had a POXO case is registered against the father. Thereafter, the father has filed a quash petition, and that complaint came to be quashed by the High Court. As considering in this backdrop, as already the allegations are made against the father, this court wanted to interact with the child, and at length this court had interacted, and the girl time and again was telling the court in the interaction that the father was inappropriately touching her. Then considering these allegations that are made, then this court has asked the advocates on both sides to be present when the counseling was, when the visitation was going on. In that visitation, the video is also placed before the court. In that visitation, mother, grandmother, the advocates and the neighbors, maids were also present. In that visitation, after the visitation, this court has again interacted with the girl. In the said in that interaction, the girl again said, when she met the father on that day in the presence of all these people, the father has inappropriately touched her, and she has given the instance of where the father has touched her. Then this court has also, after the interaction, this court has spoke with the advocates, with the mother, and also court had seen the video. Everybody on the day has stated that there is no such possibility with regard to the said allegations made by the daughter. Then at that point of time, this court wanted the daughter to be evaluated by the doctors. Why the girl is making those kind of allegations against the father? The mother at one stretch is saying about the future, the welfare and the well-being of the girl. But when it practically, when she's really interested in the well-being of the daughter, she also has to do things which are good for her in the long run, which are good in her interest, but not the things which the girl likes and dislikes. On the last occasion also, when an order is passed repeatedly, the mother was submitting to the court about her academics, how good she is in academics, and if she doesn't go to the school, how it is going to have the impact. But in the considered opinion of the mother is missing one important aspect, that the manner in which she is responding towards the father is something which should draw the attention of the mother more than anything. A child development should be holistic. A child who is very good at academics it is not the development and well-being in all respects. There should be a positive development of the child. This court had perused the entire report and the sessions that went on, and also in the preceding paragraphs, this court had uh, extracted the report, a part of the report, which the learned senior counsel is relying on. In this case, before the doctors, the girl submits that right from the she's unhappy with the father about what has happened when she was born. And she says that the father has inappropriately touched her during the visitation in the clubhouse. And it is also stated that it has never happened before. Only on those in the sessions in the clubhouse it has happened. But basing on what she said earlier, a POCSO case is registered against the father. This court is not going into the the allegations, whether it is right or wrong, but the statements that are made by the daughter. And there is no nexus between what she is saying at one session and what she is saying in the other session. That prima facie appears, and even a layman can understand that she is undergoing some kind of a psychological uh, issues which needs to be addressed. Now, a perusal of the report that is placed before the court and the covering letter that is addressed by the NIMHANS, it is clearly stated that her evaluation cannot be possible by as an outpatient. And in fact, in this particular case, this court has interacted with the director NIMHANS, uh, considering the concerns made by the mother and also the concern of the court, considering the age of the child, wherein the director has said that in these kind of cases where where mother and father are having a long-standing disputes, and the child who is with the mother, being the custodial parent, and when they come for the as an outpatient, when they come for the counseling or the therapy sessions, that is for 1 hour, and after next 23 hours they'll be with the parents, and it is very difficult for them to find out what exactly going on with the child's life and with the child's life. In those circumstances, it is very much required that the inpatient admission is necessary. Then the senior counsel had appearing for the father had relied on the judgment of the apex court in Amrita Sinha's case, and that the same is distinguished by the senior counsel appearing for the mother, that that extreme step of admitting the child in the hospital is not necessary in this case, because in this case the mother is cooperating with the father and also obeying the orders of the court. The distinction cannot be about the the obedience or disobedience of the orders of the court. In the said case, in Amrita Sinha's case, the girl is completely reluctant to see the father. To evaluate what is the reason, the doctors at NIMHANS wanted the girl to be admitted. Whereas in this case, the girl is making allegations against the father about inappropriate touch and also a case under POCSO is registered. And when the girl is evaluated, she is making very contradictory statements in each session, and there is no basis on why the girl is not interested to see the father. This is the condition which needs to be addressed. Otherwise, it would have a long-lasting effect on the life of the child. This court exercising the parent patriae jurisdiction is more concerned with the welfare of the child than about the concerns of the mother and the father. In these kind of disputes, often the parents forget about the welfare of the child and more concerned with their disputes. In this case, unless and until a continuous assessment is done by the doctors for 3 weeks, as stated in the said report, it would be very difficult for the girl. It would not be in the interest of the girl. This case from the last 1 year, this case is coming up before the court, and this court has passed several orders considering the interest. When on the last occasion, mother has stated that the conditions are not hygienic and they are not interested for admission, then the court has also, though the mother has not shown any respect to the orders of the court, still the court had given her, as per her request, this court had directed the NIMHANS to assess the girl as an outpatient. Now that this is the present report that is placed before the court is clear that kind of the assessment cannot be done without admitting the child in the hospital. Then coming to the facilities that are available at the hospital, this court that there will be a direction to the NIMHANS hospital to provide the child to provide the child an accommodation with utmost hygienic atmosphere, and also that she is kept away from other patients who are chronically ill. Accordingly, this court is passing the following order.
Just one submission, apologies. The timeline of 3 weeks, my lords just mentioned.
That's not there in this.
It's not there. It's not
No,
there.
no,
Just
that
wanted
is
to
there. That
clarify.
is there in the.
No, I just wanted to clarify that in this report, it may not be there.
The report said 3 weeks with father, 3 weeks with mother. That was the earlier one. Your
No,
Lordship.
no, no.
No, that is
Earlier,
the
That was
other
the
order,
earlier report.
not in this.
earlier they said, not this report.
No,
This
not
it
this
is
one.
not.
Earlier
This one
report
here.
they said that it
That's
is 3 weeks.
Correct.
So we'll say 3 weeks. This court is passing the following order as per the report dated 13/6/2025. When the girls' exams are.
When
It starts on the 18th.
Huh?
Next
18th.
week to end of the month.
18th July onwards till end of the month. It's her school exam.
1st of August.
There should be some date. What is this end
What
of
is
the
the
month?
So 1st of August we could
18th
start.
to 27th.
27th is over. The girl shall be admitted in NIMHANS on 28th of July by 11:30, and the doctors shall evaluate the child. The doctors have to take a decision along with the child, whether the presence of the mother, father, whoever it is necessary in the interest of the child. The mother, it should be the prerogative of the NIMHANS to do the evaluation as required, and the mother and father has no say on how the treatment has to, the evaluation has to, not treatment, evaluation has to go on, and neither the mother nor the father shall interfere with the evaluation, and they have to strictly act in accordance with the directions of the NIMHANS. Once the NIMHANS, once the evaluation is done, the NIMHANS shall place a report before this court. In the earlier order, in the earlier report, earlier report, it is stated that 3 weeks of admission is required. After 3 weeks, a report shall be placed before this court. Once a report is placed, list this matter.
In fact,
Lordship,
just one
earlier report
submission,
was-
one submission. Last time, 3 weeks, if my lords are taking of that 1 week, in fact, the child was there. Be that as it may,
No,
even
no, no.
now, while the sessions can be done as per the requirements of NIMHANS, when they do the sessions, but since the girl is 8 years old, the girl cannot stay there without the mother in that room. She can't stay alone, an 8-year-old girl. Sessions are as per NIMHANS. However, they want to do the sessions, whether alone or with anybody. that is
Then
up to
again,
them.
it's the
But
same
girl
thing.
has to be there. A mother has to be there. How can the girl, an 8-year-old girl, live alone in a institution, in a hospital? Even last time for 1 week, her mother was there with her. Last time also for 1 week, her mother is there with her. Mother
Then
has
it
to
defeats
bathe
the
her.
very purpose.
No, you can't send an 8-year-old child, my lords. The sessions will be with them. The sessions will be separate from her room where she's staying. But a mother, a parent, she cannot be without a parent. That's all I'm submitting. The sessions part, obviously, it is as per the NIMHANS doctors, how they want to do the sessions, and no parent can interfere. That is, there is no difficulty in that. But
Your
the mother
Lordship,
will stay in
whether
the
the-
hospital.
Then in that case, your Lordship,
Mother
his mother can also be there along. Because the intention of your Lordship would be completely defeated if
Mother
again
should
the
be
mother
there
is
and
staying here with her all through, again the same allegation.
Whether the presence of the mother,
to live with her in the
whether the
inpatient.
presence of the mother is required, it is for the NIMHANS to
Please.
take a decision.
Last time, I'm
If,
sorry, my lord,
if the
this is
mother's
a-
presence will have an impact in evaluation, they should ensure that the mother shall be with the child. If it is not in the interest of the child or it is difficult for the evaluation, then it is for the doctors at NIMHANS to take a call.
No, if something happens to the child in the evening, who is going to look at the child?
Lordship
Basic
could
needs.
also
She's a
put in
critical
that,
child. I mean, if
the,
that is what a
the
parent
grandmother-
or a father thinks, that the child
No,
is.
that's what
my
is the
lord,
order in this case.
That with great respect, that is.
The
that is not
paternal
how I
grandmother-
I cannot, you can say, but I cannot say.
Your Lordship,
No, the
Your Lordship,
order of-
just two other things, Your Lordship. In Your Lordship's order directing them, Your Lordship had earlier said that which is not yet done, if it could be recorded again. Two things, Your Lordship, with respect to the psyche of the parents and then parental alienation, all of that, if that could also be in the report in the
They
end of
said
it.
it is so far not done. As per the report, everything they will do.
Your Lordship, if it's
As per
mentioned,
the,
because
as per the,
they
as per
want a
the
child or
letter,
they want
as per the letter, placed before, as per the letter addressed with the covering letter of the NIMHANS, they have mentioned about,
parental
Uh,
alienation.
No, the mention is about many things. It is not just parental
mentioned
alienation.
about evaluation.
It is about many
management,
things. Evaluation, detail,
Evaluation,
etc.
management, and to evaluate the possibility of parental alienation.
No, family history, serial, all
That
of
is
that.
family therapy is under management.
No, exactly, all of it.
All of that, that's what.
Yes,
Just
yes.
alienation is
Ah.
not the only issue. All of it.
As mentioned that in that about evaluation on different aspects. The second is with regard to management. Third is to evaluate the possibility of parental alienation. On all these three aspects, on all these three aspects, the NIMHANS shall complete the evaluation.
Your Lordship, on 12/6/2024, that is 1 year ago, Your Lordship had specifically said that the court had assured that nobody can take her away from the mother. Then the girl said that all that she stated about the father was not correct. Your Lordship, if that could also be extracted, reason being,
All of that
please,
is
if
I said so.
And
Your
also
Lordship, that's
extracted
not-
all of that.
I said,
Please.
the whole reason for this court to, direct the child to be admitted in NIMHANS is that because before everybody, she said that he has inappropriately touched her.
correct. Your
That's the
Lordship's
reason.
observation is not there in that, Your Lordship, because on 12/6, Your
There,
Lordship
my lords have
specifically spoke to
extracted all
her.
of
The
it.
reason, the only reason I'm asking this is, I know that this order will also, even before the sessions are over. And therefore, your lordship, it would be important that wherever your lordship's recorded on
No, but
12/6.
that order is extracted.
Please, have orders,
That order
please.
is extracted.
Please, please.
All the orders are extracted.
Please.
My lords have extracted all
12/6
the
order, if
orders.
it is extracted, your
Yes,
lordship.
yes, next.
12/6. Obliged.
Next, we have so many material that is not considered.
The respondent merits. Whereas the original proceedings itself has been disposed of,
Disposed of.
which this writ petition has.
That is MC number?
GNWC.
GNWC. It is submitted to
94
the
of 20.
GNWC.
Your lordships, to that effect, I'm filing a memo.
It is submitted that the GNWC itself is disposed of by an order dated 3/5/2025, and hence this petition has become infructuous, and accordingly they want to withdraw the petition. Dismissed as withdrawn. Next.
Much obliged. For the petitioner, your lordship, I have filed this petition for modification of the order dated 16/4/2022, by which the petitioner.
16/4/2022.
Yes, your lordship.
Why you have realized it now,
It is filed in the year 2023, your lordship.
and it is this thing now?
Your lordship, the thing is, in the meantime, lots of negotiations were going on, mediation was going
What is
on.
that order to be modified?
Your lordship, only 5,000 has been awarded to her as an interim maintenance. Your lordship may see, he himself is there in page number 81. The assets and liabilities is not in format, first of all. He
That's
himself
not
is.
called, now this writ petition is pending. This writ petition is pending.
Yes,
Interim order is granted.
no, not in this interim order is granted, yes, your lordship. Against that interim order, we have come before this, your lordship. Only 5,000 was granted for modification of that order. He himself is
So
saying,
trying to say the order passed by the court, you want enhancement of the maintenance.
yes, your lordship.
Where is the other side? No notice is.
Notice
issued
has
now.
not been issued. Another thing I want to brought to your lordship is,
Notice to the
another.
respondents, petitions
Your
permitted to
lordship,
take out hand
one,
summons.
your lordship,
Referring
one
to the
submission, simple
respondent and file a
submission.
memo to
I
the
filed one application for stay also. The reason is, the petitioner has filed one application under section 125. And thereafter, he is not giving that one. 6,000 is awarded there. He is not giving that. Execution petition has been filed, and that is, we are not able to serve that. It is in West Bengal. So that is.
We can't help it. We can't help it. I'll not stay. So the proceedings of the MC basing on this 2023 writ petition.
Your
A
lordship,
petition
can
is
a
permitted
short
to take out
accommodation
hand
be granted?
summons. Once a memo is filed, then list this matter. Next.
Obliged.
My lords, the Honorable Principal Judge Family Court has been he disposed the petitions, which is the MC number is 357 and 2900 on 10/3/2025. Hence, this instant petition is been infructuous. I'm filing a memo of withdrawal.
That the main petition itself is disposed of on 10/3/2025, and this has become infructuous, and accordingly dismissed as withdrawn. Memo is taken on record. Next.
For petition, my lord, filing memo of withdrawal. The reason being the petition has become infructuous.
It is memo is filed seeking withdrawal of the petition that the main petition is disposed of, and this has become infructuous. Dismissed as withdrawn. Next 14.
Wife filed this petition for enhancement of the maintenance.
Notice.
5,000 is granted.
Notice to the respondent. Hand
Stay of,
summons.
stay of further.
No, hand summons. Once the memo is filed, list the matter. Next.
I filed the wakalat behalf of the party in person appearing before this court. This petition is filed for the speedy disposal of the cases.
What is the case?
It's a matrimonial case for the divorce applied. So,
Which
it has
court
been
it is? Which court?
fifth additional
MC
magistrate.
of 2024 to be disposed of.
Yeah, because it is already, it was being disposed on the merit in 2010. They have challenged it. And the,
Challenged in which year?
in the 2010. And again, it was being disposed through the Supreme Court on the jurisdiction, only on the jurisdiction to be applied on the same jurisdiction which has been there. It has been directed by the Supreme Court in 2023.
MC is filed for divorce.
Filed for
Age of the
divorce.
petitioner is 76 years.
Yes, since from 20 years, the case has been filing, ma'am. Since from 20 years, from the Nagarkoil, they have filed, the petition was being filed.
The
And the respondent has been filing various cases for maintenance. DB action.
original, where is that 2010 MC? No material for 2010.
Synopsis in the document portal. In the synopsis, it is mentioned as 6/8/2007. The petition is filed.
What is the name?
HMOP
Where is that?
48 of 2007.
Where do you get that in the synopsis? Which serial number?
Serial number 7. And in serial number 9 is the date of divorce been granted.
What is this MC number 1546? HMOP number 48 of 2007. What are they? Who filed restitution of conjugal rights? Wife.
A respondent that filed and that was being dismissed. Sir. Dismissed by the honorable courts.
It is in Tamil Nadu. One is in Tamil Nadu, one is in Bangalore.
The cases were being filed in Tamil Nadu earlier.
He filed in Tamil Nadu.
Yeah, he filed in Tamil Nadu and he got a order for the divorce. Then they have filed in High Court of Madras, and they.
Then the Supreme Court said that the courts at Tamil Nadu have no jurisdiction. It has to be in Bangalore.
Yeah, yes. The judgment in the Tamil Nadu High Court was on the jurisdiction, stating that the respondent and petitioner were staying in Bangalore, and it has to be filed in Bangalore. And only on the jurisdiction, the Supreme Court has directed to file a case in Bangalore.
No, I'm not able to understand one thing. When an order is passed on, what is the date? 17/2/2010.
Yes.
From 17/2/2010 to 2024, what they are doing?
No, they have gone for a appeal in.
Supreme Court, it is pending from 2010 to 2024.
No, 2020 to 10 they have gone for appeal in High Court, in Session Court. Session Court, it got dismissed on the merits on our side. Again, they have filed in 2018.
But GNWC will go. This will go straight to the High Court. Why it will go to Sessions Court?
No, High Court, they have gone to High Court in the year 2019, serial number 14. Order.
Second appeal was
Mm.
to 2010.
The High Court.
High Court, yeah, 2010 order.
What you wrote is they went to the District Court Kanyakumari.
Mm.
District Court
Second appeal.
confirmed that they divorced.
What is all this?
They have gone for the appeal in the Session Court. Actually is.
Once the OP is dismissed or allowed, it will go to the High Court. Why it will go to the Sessions Court?
No. Session Court. No.
First appeal. First appeal, they have gone to District Court. It was allowed. It was not allowed. Sorry.
Can you come? The petition is filed seeking
Confused with.
early disposal of the MC number 20 to MC number so and so of 2024,
Wait.
pending on the file of the third additional family court for a third additional principal for family, the third additional family court, Bangalore. The facts of the case are the husband has filed the restitution, had filed the HMOP 48 of 2007. Seeking divorce and at the courts at Tamil Nadu, and the wife had filed MC number 1546 of 2007 before the 6th additional principal judge family court Bangalore, seeking restitution of conjugal rights. The petition that is filed by the wife seeking divorce came to be allowed on 17/2/2010. Then the wife had preferred appeal, that is CMA number 16 of 2020, came to be dismissed on 31/3/2010. Then the wife had filed 2nd April CMSA, and that came to be dismissed on 24/10/2010.
Judgments are allowed to wait.
And the relief that is sought by the wife for restitution of conjugal rights came to be dismissed on 29/10/2018. A case that is filed in 2007 is dismissed in 2018.
Yes.
And the CMSA number 48 of 2010 was allowed by judgment and decree dated 31/8/2010. What is this petition? What are these dates?
Maybe pursued the annexure A produced before the court. So it's a page number 11. Order of the Supreme Court.
Why? That's what I want. That's why I'm looking at the chronology. No, 2021. When is this order passed?
2021.
From 2021 to 2024, what is he doing? MCs of 2024.
Yes. Yes. They've been filing multiple of cases against him for the maintenance, and the court has been ordered the maintenance, or he's challenged the maintenance. Finally, the evictions.
Let them wait for some more time. Let the court take its own course. It will take, now it is 24. It will be disposed of in 30. Then again to go to Supreme Court and all, there is another 10 for 10,
He is a
15 years.
layman and he doesn't know the process of law, and he has been appearing as party in person in all the cases. And once he has approached us, we have guided him. This is the procedure of the
When
law.
SLP was filed, there it is stated that the courts at Tamil Nadu have no jurisdiction and he has to approach the courts at Bangalore. Thereafter, he has filed the present MC seeking divorce before the third edition, principal third additional,
Fifth additional.
fifth additional family court. This court is not issuing any directions to the family court to dispose of the matters which are prior to 2020. As there was a specific direction by this court to give priority to the matters till 2019. But in this case, the litigation has started way back in the year 2007, and the age of the petitioner is 79 years. Considering this court deems it appropriate to direct the family court to dispose of this matter expeditiously within a period of 8 months from the date of receipt of the copy of the order. Same notice to respondent is not necessary.
18 months ago. Janardhan.
It is there, no? Why your name is not there in the list also? When did you
It is, I
file?
have filed the wakalat in the, it is there, ma'am.
So submit study as file wakalat. Next.
Leadership. Leadership, firstly grateful for having it today because it was yesterday. Now, Leadership, there are two connected matters. One is the GWNC, which is item 17.
So
And
what is the relief that is sought in 16?
16, Leadership, what we are saying is that we want the MC to be disposed of expeditiously. Now, to that, Leadership, on the last date, what Leadership had said that 3 months was given, that we had sought for. We had sought for 3 months.
But I didn't get,
You did not get.
grant any time.
But
But I
le-
made it very clear that 2019 matters are going on.
Yes.
And they will only, now what the High Court has asked the family courts, that all the IAs from in 2020 to 2025 matters, where there is urgency, only to hear those matters. Otherwise, only their matters pending from 2013 also in the family courts. So from 13 to 19 only they have to hear the final hearing matters. Like the earlier matter, as you see.
Yes, I saw that.
Only, except that, no other matters, no directions. If there is any IA pending, only they will hear the IAs. There cannot be any direction to dispose of the MC expeditiously.
Now, Leadership, I will not press on that right now because I'm more keen on the next matter, but I will argue both together. The reason I'm saying this is a child custody matter. And I have been, Leadership, the only issue in this case is
Interim custody is granted.
interim custody has been granted. In visitation rights have been granted, not once, several occasions.
So that you have a mechanism to which the
Ladyship,
violation is there.
But Ladyship, the problem
What
is,
is, who filed GNWMC?
I filed it.
GNWC?
In 2020, I filed it.
Then if she is disobeying the orders of the court, then you file an application before the court.
Now, Ladyship, this is item 17.
So then to strike off for defense or whatever. it is.
Ladyship, this is what's the problem. We are on item 17. What has happened is,
Give 17.
yes, Ladyship, I'm grateful. This is the only court where this case can be resolved. Because of so many breaches which has happened, and they absolutely hardened that nothing can happen to them. I will first
Then in
give a
that-
flavor of the case.
No, in that case, we have to use, you have to take notice to the respondents.
I understand, but I want to first give a flavor of the case for 2 minutes, Ladyship, because
No, but what, because nothing can be done now.
No, no.
You take hand summons, we'll give you a short date, then let it.
Ladyship,
come
I
back.
understand, but allow me to explain the case so that Ladyship, because we want this case to be heard in the chambers subsequently. I want to just give, like the way Ladyship had, I just want to say one thing, like the previous case Ladyship had decided, the Goldie Sharma. Now Ladyship, only after the court's intervention, till date, all visitations are happening smoothly. Ladyship would recall that mother for 2.5 years did not let the child meet the father. But only after the intervention of this court, now all visitations, half vacations, everything is happening smoothly. So Ladyship, the point is, it's how it is approached. Now what is happening in this case is that, and interestingly, in the final order which Ladyship passed on 8th of July 2024, this judgment also was referred to, in which Justice Nagprasanna had directed, because the mother is repeatedly flouting the orders of the court, I am devising a mechanism that for 1 month, the child will be sent to the father, so that that's enough time for the child to reconnect ties with the father. And after that, we'll go back to the family court, and the family court will hear the parties on visitation, and then decision will be taken. Now, Ladyship, what is happening in this case is that the family court passes orders, weekend access, daily video calls. None of it has been adhered to even once, barring the first day of the court.
Then did you file a contempt?
Ladyship, I'm explaining what all I have done in this case. So first, the family court passes an order way back in 2022 after 14 listings. That's when I get involved in the case. 10th of February 2022, first order of Sunday access and daily video calls. After that, the interim order comes to be passed during vacations in the month of April, that I'll get weekend access from 10 a.m. till 6 p.m. Saturday, Sunday, and daily video calls. Thereafter, Ladyship, the final order comes to be passed, reducing it slightly from 6 p.m. to 3 p.m. Against that order, I come before the writ court and say that my rights have been reduced. Then Justice Nagprasanna in the order has passed that because of the conduct of the mother, that she is repeatedly flouting all the orders, there are violations, not a single day she is permitting, and she's also not filed a single case of modification of the order. Said 1 month because of the conduct.
What is the age of the children?
Ladyship,
Age.
the age of the child when the litigation started was 9 years. Now he's 14 years. And Ladyship, the interesting point is that after the order came out, even then she never permitted. So I filed a contempt before the Honorable High Court. The Honorable High Court in contempt did not give any hearing to the father, only in open court, only in camera proceedings, spoke to the child and said in 1-2 paras, child doesn't want to go, and he said 2-3 reasons, that my passport is with the father, etc., and said I cannot implement the order. Against the order, I went to Supreme Court. Supreme Court said these observations cannot be taken into account. There's already section 45 which is pending for contempt, that will be taken for consideration. Now, Ladyship, I come back again before Justice Nagprasanna by saying that your order, because you said in the event there is shifting does not happen, then the court can pass adverse orders. I moved an application, but the court said the correct remedy is not here. So I approached the family court again. The family court said section 45 is what is to be done. I cannot pass this order again. So section 45 inquiry proceedings will go on. Now, Ladyship, can imagine the mother throughout this litigation.
What happened to that?
Section 45 is still pending, Ladyship. It's still pending. But the point is, we have challenged that order. That once the court has already stated the Honorable High Court that shifting has to happen and then the child has to be spoken to. And if there is no meeting thereafter, then the court can even consider shifting of custody. This is recorded in the order. Now, ladyship, again I go back to the
No, what I'm not able to understand is,
ladyship.
how can you take a clue from the order of Justice Mahaprasana and seek such a relief?
Ladyship, because what's happening now is I have zero.
You have gone to the Supreme Court. In the light of the Supreme Court order, the family court has passed this order. Why should this court will interfere with that order?
Ladyship, the Supreme Court only said that the observations of the High Court will not come in the way. In the
Let's see the Supreme Court
Yes,
order,
ladyship.
page number.
Ladyship will see. Ladyship, it is on page 330. Sorry, 389. 389.
We are not inclined to entertain this petition. We clarify that the observations made by the High Court in the impugned judgment and order would not affect the proceedings initiated by the petitioner under section 45 of the Guardianship and Wards Act. Now, where is the impugned order?
Impugned order with respect to this court? Yes, that annexure A, ladyship. The impugned order is annexure A, page 42.
What is IA that is filed?
The IA which has been filed is for shifting of custody. We are saying that in light of the conduct of the mother and in view of the order passed by the Honorable High Court, that the leadership, the most important point is to see the order of the Honorable High Court. Why there were three categories of the order was passed: first situation, second situation, third situation. So what we are trying to say that the Honorable High Court.
Let's go to Justice Nagakrishna.
Yes, leadership, I'm so grateful. That leadership is annexure AC starting at page 289. But leadership will see para 300, page 312, which is the operative portion. 312.
305.
Para 15, leadership. May I read, leadership? Yeah, sorry.
Yes.
Para 15. A collation of the judgments of the apex court as extracted herein above, the court has permitted shift of custody of the minor child.
I think the 305, it is not there.
312, ladyship, para 15.
One more. Yes.
May I read, ladyship? Yes, grateful. A collation of judgments of the apex court as extracted herein above, the court has permitted shift of custody of the minor child to the other parent when the other parent has violated orders of the court but holds that in the best interest of the child, the court should pass appropriate orders. In light of the afore narrated piquant situation and bearing in the interest of the child as also the attitude of the wife in not adhering to the orders of the court, I deem it appropriate to give the following directions. First, the petitioner father shall be entitled to interim custody of the child, Master Samuel, for 1 month from the date of receipt of the copy of this order, which would be enough for bonhomie for the father with the child. This direction is rendered only for the reason that the respondent wife is not permitting visitation despite repeated orders and warranting shifting of the child from her shoulder. After 1 month, the concerned court before whom the proceedings are pending in GNWC 128 of 2020 shall interact with the child and then pass appropriate orders for future visitation. Part 3. It is made clear that in the event the wife violates the orders passed by the court with regard to visitation, the court would be at liberty to pass appropriate orders in accordance with law, which could even be shifting of the custody of the child to the hands of the father. The mother shall be only responsible in the event court would get constrained to pass such an order. Ladyship, this is the observation. Now, there is a couple of paras more I want to show when the court records her conduct in the order. One is page 303, paragraph 13. The last 8 lines.
No, you're seeking for the direction at paragraph number 3. The court has given liberty to the family court. If in the facts and circumstances, the court wants to pass such an order, court has not given a positive order.
The only reason is that the court said 1 month time has to be spent.
Understand the difficulties, but there is a way to get your order. Now,
Yes.
you have already filed a petition for contempt. And also, because she is violating the orders of the court, in your divorce petition, you can file an appropriate application.
Ladyship,
or in the
that is the other matter, the MC case, where she is every single day taking a date for some reason or the other, when ladyship said no further adjournments. But I don't want to come to that right now, because this is a major issue. The fact of,
See, take out notice on the counsel for the respondent.
in both the matters,
No, that matter not required. Anyone going to dismiss it?
no, ladyship will not dismiss it now, we'll keep it on.
The next
Ladyship,
matter.
I want to just say one thing, ladyship, that this is a case
In
when
both the cases, any of that order that day will itself I'll pass. 16 and 17, the counsel for the petition is permitted to take out hand summons and the counsel appearing for the respondent. Once the memo is filed, list the matters.
can a date be fixed for the matter?
No. The moment you file the memo, next day it will list. That's what the direction is.
Okay, the day the memo is filed, the matter.
Memo file indicating who is the advocate on whom you have served, along with the hand summons.
Grateful, ladyship, thank you.
In addition, notice to the respondent.
Grateful, ladyship.
Serial number? Morning, somebody asked.
Oh, my lords, I'm sitting here from the morning.
You okay? Somebody has mentioned.
I don't know, maybe they might have some other number, maybe lords.
Take out. File is not there. Any urgency in this?
Yes, my lords, I'm just,
Monday?
it's just for the disposal, speedy disposal, my lords. I filed
Which year is that?
2023 in respect of the divorce case, my lords. I'm not claiming it.
Court, which court?
Principal Family Court, my lords, Bangalore.
So anyway, it's good that the file is not there.
My lords, what they have done in this is the respondent is not appearing before the court and he has filed a GPA through his mother. He has went to Dubai and I'm.
No, those are all different aspects. As far as disposal of 23 is concerned, we cannot grant that order.
The concern is, my lord, I'm the single daughter. Even my father, due to this depression, is undergone with the open heart surgery as well.
But we'll see. Monday. But try your luck on Monday.
My lords.
Yes.
Obliged.
Whatever day that's coming Monday, change it to Monday. Yes, next.
Obliged.
19.
This I appear for petition, my lord.
Mm.
The petition, my lord, husband petition, my lord. The petitioner is married, my lord, of the second respondent, your lordship.
What is the impugned order?
Impugned order, my lord, awarding maintenance of
How
rupees
much is
12,000,
awarded?
12,000 rupees, your lordship. 12,000 rupees, my lord.
12,000.
12,000, your lordship.
What is your salary?
Salary, my lord, is 40,000. I have produced the pay slip itself. 13,000 will go to the rent, your lordship. Rent agreement also I have
How much?
produced.
13.
13,000. And 11,000 will go to EMI, your lordship. I have two aged parents, your lordship, aged parents, my lord. My father is suffering from cancer, my lord. I have produced the medical certificate also before the court also, my lord. Without taking into consideration, my lord, straight away he is working as an executive engineer.
Half of the land calls for the petition submits that the take home salary is 40,000 and 13,000 goes towards the
So rent, my lord, and EMI.
11,000 towards EMI and the father.
And father is suffering from cancer, your lordship.
Cancer, half of them are.
Little lesser, your lordship. He is working as an executive.
6,000.
She is an MCOM graduate, your lordship. She left the job deliberately, your lordship.
Six,
She was
six.
working, my lord. She they left the
Arrears
job.
also at 6,000, 8 weeks. Next,
Grateful.
notice to the respondent.
Serial number 20, I appear for 20.
Inform to the other side. No. He said there is another connected matter. RPFC
There
is
is
there.
an interim order in this, your lordship.
Extend the interim order in 20. List, some date is given. Yes, next. 21.
My lordship, kindly extend 15 days time may be granted. So we need to go through some details and documents. Also have to be ascertained.
What is the?
The argument was the wife is employed elsewhere and earning sufficient salary. This honorable court directed me to produce the bank statement. I have produced the bank statement from 2020 to 24-25.
What interim order is there?
Except not interim order, not 20,000 is the amount fixed. That is reduced to 10,000 by this honorable court. Of course, not arrears, not along with arrears, it is deposited and I have received the amount. And current maintenance is also being paid as per the interim order passed by this one.
At the request of the counsel to the petitioner.
Last date of hearing, nobody represented, my lord. Your lordship fixed the date today. Today, not the.
Why there was no representation on the last occasion? This is matter on 28th. No further adjournment will be granted. Next.
And for the respondent, Your Honor.
Land counsel, the petition is present, no representation for the respondent. Lists this matter on 11th of August.
After the petitioner, my lord, a trial court has passed an order without considering the averment made in my IA in 127 proceedings, my lord. I have requested for the account detail of the respondent, my lords. But the trial court has mentioned in his order that they have produced a document. May I place the entire document, whatever they have produced, before the trial court, my lords?
You for petitioner.
You are ready? You are for the petitioner.
Petition.
You are for?
Serial number. 18491.
8120 is called.
Sincere apologies.
Petitioner present, ma'am. Advocate absent.
This is a high court. Presence, the petition presence is not required. He has to be here. The party need not be present in the court. No representation. This matter on 21st of July. You don't have to come. Now the court has interacted. 25.
Apologies, my lord.
Yes.
I'm seeking the order dated 17/12/25 at annexure 81, my lord.
80.
Page number 81, annexure J. May, para number 6, my lord. In page number 85.
Oh, section 91 of that application is rejected.
Rejected by stating that they have produced a document, but they have not at all produced any document, and
It has to be finally disposed of. Let other side come.
14th, on 14th it is posted for judgment, my lord. Till then.
What is posted? Which year is MC? What is posted for judgment?
61/24, my lord. It is second round of enhancement. Earlier also, I am paying regularly.
When is the impugned order?
Impugned at annexure J.
Date. Date of
17 February 25, my lord.
Is this matter after on 22nd?
Till then, defer the matter in the trial court. Please, my lord, it is posted for judgment, my lord.
Let it be.
I beg for the stay, my lord. My lords, the writ petition become infructuous.
Let it become. We will not stop for the proceedings on this.
Hello,
this order will merge into the final order. You can question it.
Please,
in the
my
appeal
lord.
also you can question it. Yes. Who appears? Sridhar DSB Pradeep. Where is Pradeep? Where is the calculation? Advocates are not appearing in the matters are listed. No representation on behalf of either of the parties. Delete from judgment. List this matter before the appropriate court. This also delete. No representation on behalf of both the parties. Delete the matter. Next three.
After for respondent in this matter, my lord, it was settled for global 1 lakh, my lord, case of death, my lord. Only why it was posted for judgment is the entire amount to be released in favor of the appellant, the sole appellant, my lord. That's why it was posted for judgment.
Where is the other side?
L Raja, I have informed, my lord, settled for 1 lakh. What happened, my lord? The claim petition was filed by mother and sister.
No. Is it shown in that she is the legal heir of so and so?
Yes, ma'am. Now the other sister is not dependent.
That is true. What is the business of the court to say that so and so person is?
She is the daughter, my lord. Daughter.
Petitioner number 1 died during the pendency of the claim petition. The first petitioner, this is mother. The deceased DL Sundar already legal heirs of the appellant herein. There is no other legal heir. This is DL Sundar, not made the party. The second petition made the party in the above appeal already, and also not awarded the compensation. Hence not. What I am telling is, unless and until you carry out all this and saying that she is entitled, somebody should come forward. It's not for the court to pass such an order. Delete from the caption of a judgment, post before the court, court having jurisdiction, having the roster. Next.
I'm for the fourth respondent, my lord.
Where is the counsel?
This case, my lord, I think the lordship has arrived that day about 58,000 rupees.
19,72,060.
Around 58,000 rupees, my lord.
Around?
58,000.
But where is he? That's why we have posted it for judgment.
Yes, my lord. The lordship may dictate their judgment.
Without his presence, how can we do? How can we
My
dictate
lord,
the
what
order?
happened? Instead of taking 11,000, court has taken.
Correct. Everything is correct, but he should be there when I this posted for judgment.
Court officer. Court officer. List to serial number 2 ಏನಾಯ್ತು? List to serial number 2 ಏನಾಯ್ತು?
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್
2.
ಅಲ್ಲ ಸರ್ ನೀವು ಕೇಸ್ ಅಲ್ಲಿ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಡೆಲೀಟ್ ಫ್ರಮ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಸರಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ನಾಳೆ ಡೇಟ್ ಬರ್ಕೊಟ್ರಲ್ಲ ಅವರು ಆಲ್ಟರ್ ಆಗಿದ್ದು
ಎಲ್ಲಿ ಡೇಟ್
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾಕೆ ಬೇಕಿತ್ತಾ?
ಸೈನ್ ಮಾಡಿದ್ರಾ?
ಸೈನ್ ಮಾಡಿಸಿದ್ನಲ್ಲ, ಮಾಡ್ಸಿದ್ ಯಾಕೆಂದ್ರೆ ಅವತ್ತೊಂದು ದಿನ ಇದೇನೋ ಈ ಗೊದ್ದಗಳು ಆಗಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋಡು, ಎಲ್ಲ ಉದುರ್ತಾ ಇದೆ ಎಲ್ಲಿಂದನೋ. ಅವ್ರಿಗೆ ಅಕೌಂಟ್ಸ್ ಎಲ್ಲೋ ದೂರ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ.
ಅಲ್ಲೆಲ್ಲಾರು ಹುಡ್ಕತ್ತೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಆಮೇಲೆ ಕೂತಿರೋ ಮೇಲಿಂದ ಉದುರೋದ ಕಷ್ಟ. ಟೋಟಲ್ 18 ನಿಮ್ಮ ಹೆಸರು ಇದ್ದಾರಲ್ವಾ? ಇದೆ ಕರೆಕ್ಟ್. ಇವಾಗ ನಿಮಗೆ ಟೋಟಲ್ 18 ಇಂದ ಅದೆಲ್ಲೋ ಇದು ದೊಡ್ಡ ಇರುವೆಗಳು ಉದುರ್ತಾ ಇದೆ. ಅದೆಲ್ಲಿಂದ ಉದುರ್ತಾ ಇದೆ ಅಂತ ನಮ್ಗೆ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅದು ಅಕೌಂಟ್ಸ್ ಇವ್ರಿಗೆ ಯಾರಿಗಾರ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಒಂದ್ಸತಿ. ಮೋಸ್ಟ್ಲಿ ಅದು ಮೇಲೆ AC ಇಂದ ಉದುರ್ತಾ ಇದೆಯೋ ಅಥವಾ ಎಲ್ಲಿಂದ ಉದುರ್ತಾ ಇದೆ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಅರಿಯುತ್ತೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡೋವಾಗೆಲ್ಲ ಡಯಾಸ್ ಹತ್ರ ಅಲ್ಲಿ ಇಲ್ಲಿ ಎಲ್ಲ ಅರಿಯಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿಪ್ಪ. ಒಂದ್ಸತಿ ಬಂದು ನೋಡ್ಬಿಟ್ಟು ಅದೆಲ್ಲಾಗಿದೆ ಏನು ಅಂತ AC ನಲ್ಲಿ AC ಇಂದನೇ ಉದುರ್ತಾ ಇದೆ ಅಂತ ನಮ್ಗೆ ಡೌಟ್. ಯಾಕಂದ್ರೆ ಇದೆಲ್ಲ ಕ್ಲೀನ್ ಆಗಿ ಇಟ್ಟಿದೀವಿ ಪೋರ್ಟಲ್ ಎಲ್ಲ ಗುಡಿಸಿ ಬೇರೆ ಕಡೆಯಿಂದ ಬರಕ್ ಚಾನ್ಸ್ ಇಲ್ಲ. AC ಇಂದನೇ ಉದುರ್ತಾ ಇರೋದು. ಹೇಳಿ ಅವ್ರಿಗೆ, ಹೇಳಿ.
ಇವೆಲ್ಲ ಓಕೆನಾ?
ಅವೆಲ್ಲ ಅವ್ರದ್ದೇ. ಕಾಸ್ಟ್ ಟೈಟ್ಲು ಎಲ್ಲಿತ್ತಂತದು ಬಿಂದು ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಇದು ಅಂತ. ಕಾಸ್ಟ್ ಟೈಟ್ಲು ಬೆಳಗ್ಗೆ ಮೈನ್ ಆರ್ಡರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತಲ್ಲ ಅದು
ಇವ್ರು ಮಾಡಿದ್ದಾರೆ. MFA ದಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು. MFA ನೋಡ್ಕೊಂಡು ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಅಂದ್ರೆ ನೀವು ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಜನರೇಟ್ ಆಗುತ್ತಲ್ಲ ಅಂದ್ರೆ ಮೇಘ ತಪ್ಪೇ ಜನರೇಟ್ ಆಗೋದು ಮೇಡಮ್. ನಾವು ರೆಕ್ಟಿಫೈ ನಾವು ಮಾಡ್ಕೋಬೇಕು.
ಕಂಪೇರ್ ಮಾಡಬೇಕು, ಮಾಡೋದಿಲ್ಲ. ಎಲ್ಲ ಇವ್ರೆ ಡೆಲಿಟ್ ಆಯ್ತದು ನಿಮ್ ಲಿಸ್ಟ್ ಇಂದ.
ಹೌದಾ?
ಜಡ್ಜ್ಮೆಂಟ್ ಇಂದ ಡೆಲಿಟ್ ಆಯ್ತು.
ಇವ್ರು ಇರ್ತೀನಿ ಅಂದಿರಲ್ಲ?
ಇದ್ದಿದ್ರು ಅವರು ಜಗದೀಶ್, ನೀವ್ ಇಲ್ವಲ್ಲ. ಆ ಮೇಡಮ್ ಹಂಗೆಲ್ಲ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಲ್ಲ. ಅವ್ರು 1 ಲಕ್ಷಕ್ಕೆ ಸೆಟ್ಲ್ ಆಗಿದೆ, ಎಂಟೈರ್ ಅಮೌಂಟ್ ಮೇ ಬಿ ರಿಲೀಸ್ಡ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು ಜಗದೀಶ್. ಮೇಡಮ್ ಹೇಳಿದ್ರು ವೆನ್ ಪೆಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ನಾಟ್ ದೇರ್.
ಮಂಡ್ಯ ಟ್ಯೂಸ್ಡೇಗೆ